Hi guys, hello, good afternoon everyone. Welcome back to another video at Pratham Test Prep. This is your host Sanjeet Bhatia back again with another video. So what I've done today is that we're going to discuss some of the cases that are important for your CLAT 2022 and AILET 2022, or if you're going for any other law entrance exams, these cases are very important. And I'll be discussing some legal maxims also for the day so that we can start with the legal maxim part also and we can cover it bit by bit. So I'll be discussing some legal maxims also today. So starting from the first thing that I always tell you guys to hit the like, share and subscribe button. That will be really helpful for us. If you are looking for anything regarding your updates on how the sessions are going on, questions, material, you can definitely become a part of our Telegram channel, which is under the name of CLAT@Pratham. So definitely go on your Telegram group and become a part of this so that you get free updates and you stay up to date regarding all the news that are going on under the legal arena. Now, the next is if you are looking for personalized mentoring or you want any counseling related to any of the exams, you can give us a call on 5 times 9 75392. That is something that you can definitely do. Okay, so starting with the cases for the day. What are these cases? What do we have to see if we are going for cases for CLAT 2022? AILET 2022, what are these cases like? So the first case for the day is Joseph Shine versus Union of India. Now, in this case, there was an application that was filed by the central government in the Supreme Court regarding decriminalizing of adultery under the Indian Penal Code, right? Under the grounds that decriminalizing adultery may cause instability within the armed forces, right? Because if you know that adultery is when a married person tends to have a sexual relationship with another person, is called to be under the category of adultery. Now, what they said that such crime may cause instability within the armed forces, as defense personnel are expected to stay separate from their families for a long duration of time, right? So now that is what is being said for the only for the army personnel only here. The civilians are out of the question in this case. They are just talking about the army personnel. Now, there was a notice that was being issued. The bench was headed by Justice R.F. Nariman, right? And that since the clarification is sort of a constitutional bench judgment, it is appropriate that the matter is placed before the CJI, who may issue orders to post it before a 5-judge bench, right? So the person who was taking care, Mr. R.F. Nariman, said that as the case was coming from a constitutional bench judgment only, so it is appropriate that the case goes before the Chief Justice of India and it is posted before a bench of 5 judges, right? So he didn't want to take any decisions on this matter. So he referred this case to a higher bench or a constitutional bench so that it can be taken into cognizance and things can be solved, right? So that is the case of Joseph Shine versus Union of India. It is basically regarding decriminalizing of adultery under Indian Penal Code, right? And its relation to the armed forces. Now, coming to the next case for the day, that is MJ Akbar versus Priya Ramani. That this is a very famous case that was happening in our country. Now, there was a charge of rape and sexual harassment that was being put on Mr. MJ Akbar. MJ Akbar is a very famous politician also in our country. So now the court, what did the court do? It acquitted the journalist Priya Ramani because there was a criminal defamation case that was brought by the former union minister and editor MJ Akbar, right? So there was a criminal defamation case. That means manhani, right? As you must might have heard. If someone publishes or says anything about someone which tends to disrupt their reputation in the society or a social standing, then it comes under the category of defamation. Now, what what was the court thinking and what was the whole scenario here is that men from privileged class, when accused of sexual violence, are quick to accuse women of injuring their reputation and status. That is what is being observed for a long period of time. This makes sexual harassment invincible and silences and discredits women's voice. Right? That is what is being said. Now, the court in this case held that the right of the reputation cannot be protected at the cost of right and dignity, right to life and dignity of a woman. Right? So the court was very, very clear here that a reputation is not above the right to life and dignity of a woman. Now, next is the judgment highlighted that many other points that can treat the asymmetry of patriarchal power in society. Right? So, that there are many other points that can treat the as the asymmetry of the patriarchal power of the society. Now, what did Mrs. Ramani do? Now, Ms. Ramani verdict is a huge moral vindication of the Me Too movement and will hopefully serve the deter powerful men from using defamation laws to silence survivors. However, sexual harassment at workplace is more of a social problem whose roots lies in the patriarchal mindset of the society. So that is what is being said here. Now, as you can see that Ms. Priya Ramani has said that it is a moral vindication of the Me Too movement if such kinds of criminal defamation cases are being taken into consideration, and it will hopefully serve other deter powerful men from using defamation laws to silence survivors, right? Because as Mr. MJ Akbar has put up a criminal defamation case against Priya Ramani, so it was pretty sure that they are trying to silence the survivors here, which was not very true. Right? Because it shouldn't be done, because it is taking away the credentials of the Me Too movement also, and also silencing a lot of survivors in this case. That if they go and try to go against a person of high power, they will obviously, if they say that this person has sexually harassed me, then they would go back to the court and file a criminal defamation case, and which defamation case would definitely lead to a lot of harms to that person who's the sole survivor in that case. So definitely it has to be taken into consideration that these are being done to silence the survivors. And she also said that the sexual harassment at workplace is more of a societal problem whose roots lies in the patriarchal mindset of the society. Right? That's a pretty easy case, and if you want to read further, you can definitely go on reading about MJ Akbar versus Priya Ramani. It is a very, very famous case right now. Coming to the next part is that adoption under Juvenile Justice Act of 2015, not restricted to orphan children or those in the need of care and protection. Right? So earlier people interpreted this law by saying that it is only restricted to take children in who are in the need of care or protection, and also they are also someone who are orphaned, right? They should go for these two categories. But now what the court has said, no, the interpretation was wrong. The adoption under the Juvenile Act 2015 is not restricted to orphaned or those in need of care and protection. It can take anyone can be taken in through this Juvenile Justice Act. Now, there was a conflict of law in this case, basically, that the Nagpur bench of the Bombay High Court held that the adoption of the children, as per the provision of the JJ Act of 2015, cannot be restricted to only orphaned or abandoned or surrendered children or those in conflict of law or in need of care and protection. Right? The name of the case was Sumed versus NIL. Now, what happened in this case was that the district judge, okay, had rejected the application under the Juvenile Justice Act on the grounds that the child in this case was neither a child in conflict with law, nor a child who was in need of care or protection, nor was an orphan, nor a surrendered or abandoned child. Therefore, the Juvenile Justice Act of 2015, the provisions of this act will not be applicable on such a child. Now, a revision application was filed in this case against the district judge and the order that he has passed before the High Court, contending that the child can be adopted under the Juvenile Justice Act. Now, in this case, the court highlighted the section 56(2) of the Act, stating that the adoption of a children from another relative can be made as per the provisions of the Act and the adoption regulation. Right? So, if there is an adoption regulation and the relatives of the person agrees to it, then definitely this can be taken ahead, and it will be a part of the Juvenile Justice Act itself. Now, the section 56(2) of the Juvenile Justice Act of 2015 states the adoption of the child from a relative by another relative, irrespective of a religion, can be made as per the provisions of the said Act and adoption regulations framed by the authority also. This provision is in addition to section 56(1), which states that adoption shall be resorted to for ensuring right to family for an orphan, abandoned, and surrendered child as per the adoption regulations framed by the authority. Right? This was what the court has said straightforwardly, that they can be used for any child, right? Even if he is not orphaned or not in the conflict with law, still the adoption proceedings under the Juvenile Justice Act can be taken ahead. So that is what is being mentioned in this case even. Now, coming to the next case, that is the Supreme Court rejects the Election Commission of India's prayers to stop media reporting of the oral remarks. Right, so there are a lot of oral remarks that are being given while the cases are going on inside the courtrooms. Right, the Supreme Court, there was a petition that was filed by the Election Commission of India to stop media reporting of the oral remarks. Can you see that how they are trying to curtail the voice and how the proceedings in the judiciary are going on? That's not something that I consider to be really fair. Now, rejecting the plea of ECI to stop media reporting of oral remarks as lacking in substance, the court emphasized that the media coverage of court hearing was a part of freedom of press, had a bearing on citizens' right to information, and also on accountability of the judiciary. Right? When the people can see what the judiciary is doing, then what is the problem? Right? So media coverage is very, very important for the part of freedom of press, right to information to people, and accountability of the judiciary is also questioned in such cases. So that is something really, really important. Now, the next is that the Supreme Court said that we cannot say that the media cannot report the contents of the discussions in a court of law. Right? Discussing in a court of law are of equal public interest and would put it on the same pedestal as the final order. So the court has considered that all these arguments that are being given by these people inside the court, or oral remarks that are being passed, these all are considered to be on the equal pedestal as the order that would be passed by the court. So that is what the court is saying here. A discussion in the court is a dialogue between the bar and bench. The unfolding of the debate in the court of law is equally important, and media has the duty to report. It is only our judgment that are significant for us citizens. Right? So reporting is not a problem. They know that the judgments are the only things that would be significant, but definitely they want to take the debate out from the courtroom to the general public, which is very, very important in these cases. Right? So you have to understand this also. Now, it is said that the freedom of media to report court proceedings was also a part of the process of argumenting the integrity of the judiciary and the cause of justice as a whole. Right? So that is what is being said. The judgment also referred to the new age developments in the courtroom reporting, such as live accounts of hearing given on Twitter and other such media platforms. So there are a lot of media platforms where these kinds of hearings and the online hearings are being given. So that is something that you have to understand, that this is a new age courtroom reporting, right? And there are because there are live accounts also. The court said that the real-time updates about hearing are an extension of the concept of the open court. Earlier in the previous eras, there used to be the concept of the open courts, and that they are not a cause of apprehension but a celebration of the constitutional ethos. So that's what the court is saying, that this step shouldn't be considered as something which is against the proceedings of the court or anything of that sort, but it is something that is helping, and it should help to be celebrated further because it is leading towards the betterment of the constitution also and the rights of the people, because they can hear what kind of debates have been happening inside the court. So this is what this case says about the oral remarks and the case that was filed by the Election Commission of India in the Supreme Court regarding the live oral remarks that goes on and the media coverage of such oral remarks. Coming to the next case for the day, that is Vinita Sharma versus Rakesh Sharma. Now, this was a very, very important case regarding the Hindu co-parsonary rights. If their father was not alive, the daughters have the equal right in the properties of their fathers as earlier the sons used to have it. Right? Now, the daughter will have the share after the Hindu Succession Act of 2005, irrespective of whether her father was alive or not alive at the time of the amendment. Right? अगर जिंदा थे तो भी ठीक है, नहीं थे तो भी ठीक है, उनको शेयर मिलेगा उनकी प्रॉपर्टी में. That's what you have to remember, that a daughter will have a share after the Hindu Succession Act of 2005. Now, there was a bench that was headed by Justice Arun Mishra, pronounced the judgment in the batch of appeals that raised an important legal issue, whether the Hindu Succession Act, which after 2005, which gives equal right to daughter in ancestral property, has a retrospective effect, right? Basically, that it will be applied even before the act was there, right? अगर किसी के father उससे पहले भी चले गए तो कोई उसमें difference नहीं create होगा, and they will make sure that the property is given to the daughters also as equally as it is given to the sons. And this act will also have a retrospective effect. So you can see that a lot of daughters will get up right in their properties, and they can definitely become a part of the heritage of their own family also, because of such a act that is being passed by the legislation of the country. That is the Hindu Succession Amendment Act of 2005. Okay. Coming to the next case for the day, that is Satish versus State of Maharashtra. The contact is not a sexual skin to skin, right? So you have to understand that a contact is not sexual assault, which is skin to skin. Now here, this was a very, very like a judgment where the people came against the judgment also, because the Nagpur bench of the Bombay High Court held that the groping of a child breast without skin to skin contact would amount to molestation under the Indian Penal Code, but not as grave offense of sexual assault under the POSCO Act, which is the Protection of Children from Sexual Offences Act. Right, the single bench of Justice Pushpa Gandewala made the observation while modifying the order. Okay, so this was what was being said, that if the person is not having a skin to skin contact, then it will come under the category of sexual molestation, and molestation under the Indian Penal Code, but not under the sexual assault on the POSCO Act, which is the Protection of Children from Sexual Offences Act. Now, Justice Gendewala said that there must be a skin-to-skin contact with sexual intent, and mere groping is not sufficient for a crime to be noted under Section 7 of the POSCO Act. That is what also is being said in this case. The Supreme Court held the judgment that was being passed by the Nagpur bench of Bombay High Court. So as it is, basically, you can be very, very sure about it that such cases are always been taken a record of while they go to the Supreme Court also, and sometimes Supreme Court also takes a suo motu cognizance in such cases. So definitely it makes a lot of sense here that the Supreme Court has stayed such a judgment that was passed by the Nagpur bench of Bombay High Court. Okay, so coming to the next case for the day, that is the Aparna Bhatt and others versus the state of Maharashtra. Now, the Supreme Court calls for gender sensitization of the judges and lawyers. Now, there was a bench of Justice A.M. Khanwilkar and Justice S. Ravindra Bhatt. The justices had held that the use of reasoning and languages which dismisses the offense and tends to trivialize the survivor, especially to be avoided in all the circumstances, right? So there are sometimes reasonings and languages that are being used to diminish the offenses and tends to trivialize the survivors, that the people who survive the offenses. Now it is specially to be avoided under all the circumstances that are there. Okay. Now here the court observed that the judges play at all levels a vital role as teachers and also as leaders. It is the role to impartial in words and action at all times. If they falter, especially in gender-related crimes, they imperial fairness and inflict great cruelty in casual blindness to the despair of the survivors. As you know, there are sometimes insensitive comments that are passed by the judges in the court regarding the general sensitive cases also where one gender is being put on a huge part, right? So this has to be taken into action, and if the falter is in the gender related crimes, their imperial fairness and inflict great cruelty in clash and brightness to the despair of the survivors. Okay, they shouldn't casually be very casual about the crimes that have happened with such people. They should take it very seriously, and also not casually at all, and give a proper decision in such cases. Okay, so I hope everybody is clear with this case also. Aparna Bhatt was and others versus a state of Madhya Pradesh, right? Coming to the next case for the day, that is the legal terms that I was telling you that I will be discussing a few legal terms today, right? So the legal terms are as follows for the day. The first is animus furendi, right? Now, animus furendi, what does that mean? That means that intention to steal, right? If anyone has an intention to steal, he's said to be having the animus furendi as a legal maxim that is being used. These are very easy legal maxims, so you can definitely learn them up. There will be not a lot of problems that you will face in learning such legal maxims. Now, coming to the next part, that is the animus nocendi. Now, animus nocendi means the intention to harm. If anybody has intention to harm, the Latin maximum for that is animus nocendi. So you can definitely learn this also. I have posted a picture that you can see, and that will also help you to memorize these kinds of Latin terms. Okay. Coming to the next part is that animus possedendi, right? Which is the intention to possess. If anyone has an intention to possess, then definitely it is considered under the definition of animus possedendi, right? So that is what is being said, which is the intention to possess, right? So if anyone has intention to possess, then definitely it comes under the Latin maxim of animus possedendi. Okay. Now the next maxim for the day is animus revertendi. Now I've covered a similar type of maxim so that you can remember all of them very easily. Now, intention to return, right? In most of the cases of theft and all those things, we see this Latin maxim very commonly, which is called animus revertendi, right? So that is basically the intention to return back the property. Okay. Now coming to the next part, that is the animus contrahendi, that is the intention to create a contract, right? So intention to contract basically. So if you are reading a Latin maxim of anywhere between animus, right? The animus is the common word here. So that means the intention to. right? So if intention to and the last words will always change, so you can definitely even have a smart guess that what might the Latin maxim be. Okay, so in this case it is intention to contract, right? Which is also called the animus contrahendi. Okay, so this would be it for today, guys. I hope you were able to understand all these legal maxims and the cases that I have discussed for the day. I will recommend all of you to put a comment on the comment section so that I know what kind of videos do you need further for your CLAT prep or your AILET prep. If you want me to discuss any of the topics from the Indian Penal Code or Indian Contract Acts or torts, then do definitely let me know on the comment section, and I will be happy to help you all. Right. So that would be it for today, guys. Thanks for joining the live session. I hope you gained some knowledge about these issues that we have discussed today. Do hit the like, share, and subscribe button, and do let us know what you want to be taught next on this YouTube channel, and I'll be taking those topics for you. Right. So thank you all. Stay safe. Use your mask and hand sanitizers. Maintain social distancing, and if you are above 18, do get yourself vaccinated. Right. Thank you, everyone. Take care. Bye-bye. Keep preparing and keep smiling.